Arraignment date I have on that is 2/9, but I believe council's already filed a waiver of arraignment. That case has a pretrial of 2/27, February 27th. So you would like to just keep all the cases together for that pretrial date?
Whatever you think.
Let's leave it set for 2/27, Your Honor.
All right, leave the new law violation set for February 27th, and then add both of these VOPs to that same date.
Thank you, Your Honor. That's all I have this morning, Your Honor.
All right, thank you.
Thanks, sir.
I'm going to take them in order that they have the inmates. I think that's more expeditious. Jakia Griffin, it's number 2. I skipped over Mr. Powell's case. Talking with the attorney? Okay. How about Michael Boulaba? Tim Gibbs?
Good morning, Your Honor. Tim Gibbs on behalf of Michael Boulaba, 21 CF 2621, 21 CF 2633. Your Honor, we have reached an agreement with the state in this matter. Judge, on these violations of probation, he's going to enter an admission to the court. The agreement with the state judge is that he's going to be reinstated to his supervision with original terms and conditions. I believe he was on community control for a few months to begin, so that will remain in effect. That's also going to waive the cost of supervision. He'll need to also be fit with a GPS monitor at no more than $1 per day. That also resuspends an 80.625-month suspended sentence. And Judge, we're going to modify his probation to where he goes to the REAP program in Pensacola, allowing him to travel over there. He needs to enter REAP within 24 hours of his release from incarceration. He, of course, does need to remain in jail for that GPS to be fitted before he can be released. That also imposes $100 or $200 cost of prosecution and a $250 public defender fee. I can approach with a written plea and a score sheet.
Sir.
No objection to the score sheet, Judge. It is an hour departure, Judge, with a legitimate uncoerced plea bargain.
He's got an appeal pending, as I remember from reading the docket, where he's appealed the last sentence of imposing community control. Is that right?
Correct.
How does this impact that?
As far as I know, Judge, that appeal is still pending. And I'm not sure if this sentence necessarily will affect the appeal. This was an agreement that we had reached with the state in order to allow him back on to that supervision. He is working to transfer his supervision back to his home state of North Carolina, where his family is located. And that was one of the considerations in making this agreement.
This is a plea to community control.
Yeah.
State is community control.
Correct.
All right. Mr. Bullbaugh, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth? Yes, sir. All right, sir, I have a written plea agreement. It's dated today, January 31st. Has what purports to be your signature. Is that your signature?
Yes, sir.
And prior to signing this, did you read it?
Yes, sir.
Did you understand it?
Yes, sir.
Did you go over it with your attorney?
Yes, sir.
Did he satisfactorily explain the terms and conditions of the written plea to you?
Yes, sir.
Do you have any questions concerning it this morning?
Yes, sir.
Are you satisfied you've had sufficient time to discuss this case and your theories of defense to the charge with your attorney?
Yes, sir.
And are you satisfied with the services of your attorney?
Yes, sir.
Has anybody forced, coerced, or threatened you to enter this plea this morning?
No, sir.
Have you had any drugs or alcohol within the last 24 hours?
No, sir.
So what you're telling me is you're entering this plea freely and voluntarily of your own will.
Yes, sir.
And you understand that this plea provides for a reinstatement of supervision to the original terms and conditions of the community control?
Yes, sir.
And you've actually appealed the prior order of the court. I think Judge Ketchel entered that, placing you on community control.
Yes, sir.
I don't know the answer to this, but your pleading to community control now may impact that. Do you understand that?
Do you understand that entering this plea may impact your appeal?
Stopping as far as,
I can't say exactly how it would impact it, but it may change the outcome otherwise of your appeal.
quite understanding how it would affect the.
Well, when I reviewed the court file, the only thing that I saw on the notice of appeal was just that you were appealing the order placing you on community control. It didn't indicate what the reason was. It just said you were appealing that. I don't know whether you were saying that your plea on the community control was not voluntary. I don't know, what you're claiming on it.
No, sir. I was under the impression when I was placed on the 18-month probation, I was under the impression that I would be able to go on the 18-month probation with a transfer to be allowed to transfer my probation home. I came down here to Florida to bury a family member, and it was only an overnight stay. And I ended up getting in trouble at the funeral and got locked up. In the process, the community control was never mentioned to me by my attorney, Casey Etheridge. I didn't know nothing about it until Malcolm Harris, the probation officer, came to the jail to put me on it. And I asked him, I was like, what are you doing? Why am I going through this? And I told him right then and there, I said, well, you can go ahead and lock me back up.
So
I refused it.
So what you're telling me is you were objecting to the community control.
No, sir, now I'm trying to get to the program of REAP, and hopefully they can help me transfer home.
Not now. On your before, the last time you were in court on the case.
Your Honor, to be honest with you, I didn't know nothing about it. No one never said you going on community control. No one said I'd never be on electronic ankle monitor, none of that. The lady that was in here, when she said that she needed my name and my address, I told her, I said, ma'am, I'm homeless. And she told me that the only thing that was required of me is don't leave the state and don't leave the county. So I figured I could pay the $100 and be transferred back to my wife and children and my job and my home, but it's not worked out that way. I've been confined to this cemetery twice. I've been forced to live in the cemetery and sleep on somebody else's grave because of this. And it's getting outrageous. And what makes it so bad, the witness, Lee Spoonbar, is a deputy sheriff. She testified in my behalf, stating that I did exactly what I was charged with not doing. And it's getting to be crazy.
Well, sir, okay, now I'm not even sure you understand what you're doing today. This plea that you're entering today is for you to be placed back on the community control.
And I don't understand how it will affect my appeal. That's what I'm having a problem with right now.
How it would affect your appeal?
Yes, sir, I do not understand that.
I don't know for sure that it would, but it might, because if what you're objecting to is community control to begin with, this plea, if what you're agreeing to here is to be placed on community control.
Your Honor, is there some kind of way that I could get the courts to rule that I'd be allowed to have a transfer home to where I can go through the process of going through
I believe that's still a process through probation.
That would only be if...
I was denied that right the first time.
That would only be if your home state agreed to supervise you under the same terms and conditions of a community control. I can't tell you that they'll do that.
It's up to North Carolina whether or not they accept you. That's part of the transfer process, and that was one of the reasons we talked about going to REAP so that you could get that transfer process started.
Yeah. Yeah, go ahead and do it. Go ahead and do it.
Do you understand that we don't necessarily know how this may affect your appeal, it's just that it could, it might. We're just unsure exactly how it would affect the appeal.
I don't understand how they're applying it to me in the first place because of the timeframe. 34 years ago is when the initial,
So we're just focused on the violation of probation.
yeah, just go ahead and do it.
Do you
I'll work my
understand
way
that-
through it, yes.
Do you understand that you'll be back on
Yes,
community
I-
control for up to 6 months with the original termination date with 18 months of
Does
probation
does the
followed?
time start from where I initially got
So
put
you'll
on?
get credit for all the time that you've been on supervision, yes.
Okay, all right, that'll be fine. I'll roll with that.
Yes, it's the same. Yes. You understand that?
Yes.
Do you have any questions about
No.
it?
Let's go with it.
So you want to go forward, so you want to
Yes,
admit
sir,
the
let's
violation?
go ahead and do it. Maybe I can work something out there where I can get some.
I think
Your Honor, Charlie Rivers State Probation, to answer or to respond to something that he said, we never made him stay in the cemetery and sleep on somebody's grave.
I was confined
That was
to,
not,
I was
we never
confined to
did
the
that. He
cemetery
was
by Malcolm
homeless,
Harris.
and that's where he went. We didn't tell him that he had to go there. That's where he came up. We go.
I understand that.
Okay, yeah, we went to that. But if you do accept the plea, he has to have his own transportation to the program in Pensacola. I just want the court to be aware. We contacted Reed. Reed will not come pick him up. So he will be responsible for his own transportation to the Reed program in Pensacola.
For the court's comfort, Your Honor, Mr. Bolivar and I have discussed that. We have discussed that he does have the ability to get over there within 24 hours of his release.
All right. Do they have a bed for him now, or they don't have a bed?
They will have a bed for them in our conversations with REAP. They will accept him into the program, and they'll process him in as soon as he arrives. They'll start processing him in.
All right, then he's admitting the violation of the community control and probation.
Correct.
All right, the court then, after this discussion, is going to find that the defendant freely, voluntarily, intelligently entered his admission to the violation of probation and community control. After having the benefit and advice of counsel, the court will accept the plea. He'll be adjudicated guilty of both of the violations on both case number 21 CF 2621 and 20 FCX 2633. It's going to be judgment sentence of court based upon a agreed plea agreement between the state and the defendant that he'll be reinstated to the supervision that he was on under the original terms and conditions. That was the community control, the GPS monitoring. The state prison sentence, guideline sentence will be continue to be suspended upon his successful completion of the community control and probation. It will be modified. However, these are additional conditions so that the defendant will be required to enter the REAP, R-E-A-P program in Pensacola. Once they have a bed, he'll be allowed to travel to Pensacola, to Escambia County, for the sole purpose of entering the REAP program, and he must enter the REAP program within 24 hours of his release from incarceration. He'll be required to be held in the county jail until that bed becomes available. And once it is available, he'll have 24 hours to get to check into REAP. Court will waive the cost of supervision, and he will remain in the county jail, as I said, until a bed becomes available and until the GPS monitor is secured on the defendant. The court's going to impose $100, well, total of $200 cost of prosecution and be $250 public defender fee.
Your Honor,
He'll get credit for time served.
thank you, Judge. Your Honor, the agreement called for that he is able to be released after the GPS is fitted because he has his own transportation to get to REAP. REAP will process him in as soon as he gets there. Our understanding is that they do have space for him now so that he can be released as soon as the GPS is fitted, and from there have 24 hours to get to REAP.
All right. Okay, well, I'll allow that. Sir, you have a right to appeal the legality of sentence of the court. If you can't afford an attorney, one will be appointed for you. You have 30 days from today to file your notice of appeal. And I've indicated, this is downward departure. I've indicated it's based upon a uncoerced plea agreement.
Thank you, Your Honor. They're supposed to let you out as soon as...
Let's see, is Mr. Powell here yet? No, I don't see him. Okay. Okay. So that would be Dwayne Moore. I think that's number 1 on the inmate list. Yes.
Good morning, Judge.
Good morning, Mr. Powell.
I'm Gil Powell. I'm appearing for Bo Powell this morning on Dwayne Moore II. He's present in the courtroom. Is that you, Dwayne? This is a,
All right, this is here on a motion for early termination of probation, is that right?
yes, Your Honor.
Okay.
And he entered a plea on October the 1st, 2020. He was placed on probation for 36 months. He served 24 months of the 36. All conditions completed and all financial obligations are paid. Has no violation. I think he should be early termed.
Let me understand the facts of the case. Originally, he was placed on probation for possession of a firearm by a convicted felon. It was a downward departure, and he was placed on probation for 36 months.
Correct.
Why should I terminate him early?
Well, my understanding, it doesn't matter what he's placed on. He completed all his terms. He's paid his dues. I mean, he served 2/3 of the time, not half. You usually get off on half. He had no violations at all since he was placed on there. And,
You're-
Well, was part of his original plea that he could be early termed upon the completion of the terms and conditions? I didn't see that when I was looking at it.
I don't think so, Judge. I don't think it was any kind of conditions on it. It's normal practice that you can file the motion after 50% of the time.
Oh, I
He served-
understand that.
He served 2/3. He ought to be able to get up. I don't know what the state's position is, but
Your Honor, the state objects. While the state does commend the defendant for not violating his probation, he did get the benefit of a downward departure. My math says he still has 9 months of probation left as punishment. The state's also asking that he remain on probation. He does have some priors, including sex offenses in his past, so the state would ask that, if anything, for punishment, to let him continue the 9 months so he can remain under supervision, continue to do well, no violations, and serve out the entirety of his 36 months probation, which he received a downward departure. He did score 19 months in prison.
I'll be honest with you, that's the direction I was heading, looking at the report. You know, I'm not saying I've never early terminated a probation.
Right.
But for this type of a charge, possession of a firearm by a convicted felon where there was a suspended state prison sentence, I don't think it's appropriate to early terminate his probation. So I'm going to deny the motion for early termination. He'll need to complete his probation as originally ordered.
okay, Judge, thank you. Hang on just.
Yes, sir. Good luck to you, sir. What about
He's already denied.
Kaya Griffin? Are they ready with his?
Thank you, Judge. Thank you. Good to see you.
Yes, sir. Good luck to you, sir. All right, this is here for a bond hearing, is that right?
Yes, Your Honor. This is Jakia Griffin. We're here today for a bond hearing. Ms. Griffin currently has a $10,000 cash or professional bond. She has been unable to furnish this bond. It's too high and equates to basically a no bond in her case. Ms. Griffin is local to the Cretview area. She's been here about 8 years. She has family, including her father, who she works for. On occasion, she has a 3-year-old child, and we're requesting that the court modify the bond to signature or consider reducing to a lower cash or professional that she could possibly furnish. I believe it would be appropriate for mental health conditions to remain a term of the bond if the court would entertain lowering it, and would be open to a GPS monitor as well.
Yes, Your Honor, Arianna Leone for the state. First, I would like to inform the court that on December 29th, the public defender was representing Ms. Griffin, and they filed a bond motion. On that day, the bond motion was withdrawn. The case continued to today, and the Regional Conflict Counsel was appointed. This case involves very serious charges. The victim, Holly Fowler, has a right to participate and to be present for such a bond motion. And obviously, since it wasn't properly set for that, Ms. Fowler was not called to participate. So at the very least, Your Honor, the state would ask to continue the bond motion to allow the time for a victim, Holly Fowler, to be present.
When was she arrested on this?
She was arrested on November 25, 2022.
Why wasn't the the alleged victim notified of the hearing today?
Because when the case was heard on December 29th, the bond motion was withdrawn, and the case was reset for today after Regional Conflict Counsel was appointed. Therefore, the status of the motion is withdrawn. There is no bond motion on the docket.
And I didn't realize, my understanding was that we just continued the bond motion for me to be appointed and us to argue it. That's what I was informed. But, if the victim hasn't been notified, I wouldn't, we could reset it. It's not, but.
Seeing any of this. Isn't there a criminal docket next week? Where's the?
February 10th, I believe, Your Honor.
That would be my only issue. I wasn't aware we had another docket before. Is there one February 10th?
Next Friday. It's on a Friday.
Maybe the 9th, too.
I'm showing there's a docket, miscellaneous criminal docket on February the 9th and the 10th. It's what, is that right? Yes, sir. Yeah. I mean,
Okay.
Since the victim hadn't been notified, I'll go ahead and give you a short continuance. We'll reschedule it for February the 9th at 9 o'clock. And it'll be set for a motion for bond hearing at that time, and the state will be required to notify the victim of that new date and time.
Thank you, Your Honor.
Thank you, Judge.
Yes, ma'am.
So come see before that.
You also have Christopher Stearns, is that right?
Yes, Your Honor. And Your Honor, we have, Mr. Stearns is going to be entering into a plea agreement with the state, 131, 3. He's going to withdraw his previously entered plea of not guilty and enter a plea of no contest. And I've got the sentencing recommendation on the plea form. Would you like me to approach?
I'll take it if you got the conditions set there.
Have the state and him sign it really quickly.
Okay. Sir, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
And what is your name?
Christopher Stearns.
What is it?
Christopher Stearns.
Okay. Mr. Stearns, your attorney has just handed me a written plea agreement. It's dated today, purports to have what appears to be your signature. Is that your signature?
Yes, sir.
And prior to signing this, did you read it?
Yes, sir.
Did you understand it?
Yes, sir.
Did you go over with your attorney?
Yes, sir.
Did she satisfactorily explain the terms and conditions of the written plea to you?
Yes, sir.
Do you have any questions concerning it this morning?
No, sir.
Are you satisfied that you've had sufficient time to discuss this case and any theories of defense to the charge with your attorney?
Yes, sir.
And are you satisfied with the services of Ms. Flowers, your attorney?
Yes, sir.
Has anybody forced, coerced, or threatened you to sign this written plea?
No, sir.
Have you had any drugs or alcohol within the last 24 hours? So what you tell me is you're entering this plea freely and voluntarily of your own will, is that right?
Yes.
And so you understand that the charge for which you've been charged, felony petty theft, is a third-degree felony, carries a maximum penalty, 5 years state prison, $5,000 fine. In the event you violate your probation, that sentence could be imposed. And you also understand you're waiving your right to a trial.
Yes, sir.
All right, the court's going to find that the written plea of Noah Contendere, case number 22 CF 3069, charge being felony petty theft, is freely, voluntarily, and intelligently entered after defendants had the benefit of advice of counsel. The court will accept the plea. He'll be adjudicated guilty and placed on probation for a period of 18 months with the following special terms and conditions. He'll be required to pay complete 50 hours community service work at the rate of no less than 5 hours per month. He's not to trespass or go on the premises of any CEFCO. What is CEFCO? Is that an acronym for something?
CEFCO is the gas stations.
That's the name of the gas
Yes,
station? Okay, any CEFCO gas station. And he's also to attend and successfully complete an anti-theft course. He's not to be in the possession of or use alcohol, illegal drugs, or controlled substances without a valid doctor's prescription. He'll be required to pay $415 court cost over the course of his probation, pay $100 cost of prosecution, and you're private in this case?
I'm a $150 cost of defense. I'm with RCC. I'm appointed.
Okay, and $150 cost of defense. The court will waive the cost of supervision. Sir, you have a right to appeal the legality sentence to the court. If you can't afford an attorney, one will be appointed for you. You have 30 days from today to file your notice of appeal. You will need to be fingerprinted on this charge. Good luck to you, sir.
Meet with, you'll meet with probation today.
Bruce Yarwood is also your case?
Yes. And, Your Honor, I think there was some confusion with the orders on this case. This case was actually, it was the intent of the state and the defense to continue this matter and not to have the hearing today. So we would ask to continue to February 27th.
All right, without objection, the court will continue the matter till, now, February 27th is the pretrial date.
Yes, he has a new law that
Okay.
this is tracking with.
All right, it'll track with the new law violation, continue to February 27th at 9 a.m. Did you have another one, Ms. Flowers?
Is Gregory Geiger not on the? And Your Honor, this is Gregory Geiger. We're here in 22 CF 2274, which is a violation of probation, and 22 CF 2714, and that is a new law. He's prepared to enter a plea today. I just need the state to sign.
To both the new law and the VOP?
Yes, both together.
All right, sir, would you raise your right hand and be sworn? Do you swear or affirm the evidence you're about to give will be the truth, the whole truth, and nothing but the truth? Yes. All right, thank you, sir. Yes, ma'am. Thank you.
Okay.
All right, Mr. Geiger, your attorney has just handed me a written plea agreement. It is dated, looks like January the 25th, about 6 days ago, and it purports to have your signature. Is that your signature, sir?
Yes, sir.
And prior to signing this, did you read it?
Yes, sir.
Did you understand it?
Yes, sir.
Did you go over it with your attorney?
Yes, sir.
Did she satisfactorily explain the terms and conditions of the written plea to you?
Yes, sir.
Do you have any questions concerning it this morning? Are you satisfied you've had this sufficient time to discuss this case and any theories of defense to the charge with your attorney?
Yes, sir.
And are you satisfied with the services of your attorney?
Very satisfied.
Okay. Has anybody forced, coerced, or threatened you to enter a plea this morning?
No, sir.
Have you had any drugs or alcohol within the last 24 hours?
No, sir.
So what you tell me is you're entering this plea freely and voluntarily of your own will. Is that right?
Yes, sir.
All right, the court's going to find then that the written plea of nolo contendere to the new law violation, case number 2022 CF 2713, alleging grand theft auto, and to the VOP 2274, is freely, of all counts, is freely, voluntarily, and intelligibly entered after defendants had the benefit of advice of counsel. The court will accept the plea. He'll be adjudicated guilty and on the new law on both the new law violation and the VOP charges. He'll be on the new law violation. He'll be placed on community control for a period of 18 months, and I'll come back to the concurrent. Be placed on control for a period, community control for a period of 18 months. He'll be required to complete the Keaton inpatient treatment, and he'll be required to remain in the county jail until there's a bed available. The court is going to require him to make restitution, and I'll reserve jurisdiction on the amount, manner, and method of payment of that restitution. He'll be required to pay $415 court cost, $100 cost of prosecution, and $150 cost of defense, and the cost of supervision will be waived on both cases. On the VOP, count one, he'll be placed on probation for 18 months community control concurrent with 22 CF 2274. And well, some of these are misdemeanors. 2 of them are misdemeanors. Okay, on count 1 of the VOP, let's do it this way. I'm going to revoke and terminate the current probation that he's on. He'll be placed on a new term of probation or a new term of community control for a period of 18 months, and that'll be concurrent with 22-713, the new law violation. Similarly, he'll be required to complete the Keaton inpatient treatment program. He'll remain in the county jail until a bed's available. $100 VOP fee and cost of defense $100. The VOP is cost of prosecution. VOP cost of prosecution. The court will waive your supervision on this one as well. On counts 2 and 3, those are misdemeanors, and I'm going to do it a little bit different than what's in here. I'm going to sentence them to time served on those. So what we're dealing with are the 2 felonies. All right, so on count, is there any objection to that? I know it's not in accordance with the plea agreement, but is there any objection to that?
Not from the state.
No objection.
All right, then on counts 2, the driving while license suspended and possession of paraphernalia, he'll be sentenced to time served on those. All right, sir, do you understand the sentence?
Yes, sir.
All right, you have a right to appeal the legality sentence to the court. If you can't afford an attorney, one will be appointed for you. You have 30 days from today to file your notice of appeal. You will need to be fingerprinted, and this is a guideline sentence.
So, there. And Your Honor, I think I just have one more out of custody. Miss Savannah Matthews.
Who is it?
Savannah Matthews. 22 CF 1077.
This a VOP?
Yeah, this is a VOP, Your Honor. We thought we had, we had an offer for 90 days to revoke and terminate from the state that I just wanted to put on the record. Ms. Matthews does not want to take that offer. and has indicated to me she wants to hire private counsel. So it's my intent, I just think we need to set it for an evidentiary hearing, and if she can get private counsel before then, I told her, she would have to do that.
Drug court was also an option for the state, from the state.
I'm trying to get with Gillis Powell to get my license straightened around. He took my case prior before that. And so that's the only thing about drug court. I don't want to be able to not make it, you know. And there's something that I can set an appointment for to be able to get there or have a ride there. That's something different, but just to be able to call out the blue, then I can't just do that because I don't have the car to jump in and just go.
All right, and I communicated that to the state, that her concern with drug court was the parent transportation issue, which is why the state offered this 90 days jail to revoke and terminate. So this is where we're at.
Let's deal with one issue at a time. Ma'am, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth? All right, your name? All right, Ms. Matthews, your attorney, the first thing she said was that you want to hire your own attorney. Is that right? Do you have the ability to hire your own attorney? Oh, your father's going to help you with that? All right. I'll go ahead and allow her to do that. Then I'm not going to allow you to withdraw yet until she gets counsel and that counsel makes a notice of appearance. But how long is it going to take you to do that, ma'am? Okay, tomorrow at 11. Let's pass this then until February the 9th. I'll give you until February the 9th. You'll need to be back in court that date, ma'am, at 9 a.m. with your new attorney. All right, good luck to you.
Thank you, Your Honor. That's all I have today.
That's all you have?
May be
All right,
excused.
thanks, ma'am.
Thank you.
What about Mr. Moore? I thought I saw him in here somewhere. Where is he? Oh, there he is. Okay.
Tanya Whitfield, Your Honor. Making a notice, verbal notice of limited appearance for today's hearing. Your Honor, Ms. Whitfield's here on potential violation of probation. Her probation does not terminate until March. At issue were two matters. One was failure to complete community service hours, which she's now completed. And secondly is the payment of the fines and costs, which are still in excess of $3,000. She doesn't anticipate being able to pay those necessarily between now and March. The state's going to make a recommendation, Your Honor.
Yeah, she terminates March.
Yes.
We would need to
23-3.
We would need to extend.
That state would like to extend.
This is where we are, Judge. She violated on failure to do community service, which she's since completed since they violated her, and she owes about roughly almost $4,000. So my thought was, let's push her out, give her some opportunity to pay instead of extending her probation with an adjudication, because that's going to come with more costs, more court costs. But her probation is up March 9th of this year, so I would like to extend it 6 months to give her time to pay. But the only way that I'm understanding I can do that would be to extend it. That would be modifying the probation, which would have to come with a adjudication or a withhold. I think she was already adjudicated. So I just was trying to avoid her accumulating more court costs, because she has been making little payments here, little payments there regularly, but she just owes so much. The recommendation from probation was to extend for a year of her probation. But in order to do that, she's got to plea.
Well, if she, I get that you want to get the restitution. I think that's important.
I think it's fines and costs, Your Honor.
Fines and costs.
Yes, sir.
If,
I don't think there's any, I don't believe there was any restitution, Your Honor. This is a deal.
just fines and costs. What do you do for a living, ma'am?
I do move-out cleanings. I have my own small business. Basically, it's just me. I have small children. My Work is really slow in the holidays, though. So November and December, I didn't do much of move-outs, you know.
Well, how much do you normally earn?
Well, the realtors that I work with take up to 30 days to pay their invoices.
She's just asking how much you make a
So
month.
it just varies. Sometimes it might be 500 only, or it might go to 15. It just depends on if the work's there. If the realtors send me work orders. And then, like I said, they have 30 days to pay their invoices. So there's months that I'm waiting a month for, you know what I'm saying?
Well, I get that they pay you in arrears, but your average monthly income is what? You said anywhere between?
I would be safe with possibly probably only, I honestly, $800.
You have any other source of income?
No.
There's two options. One, you go forward with the VOP once she admits it and we can extend her, or the fines and costs can be reduced to a lien.
Your Honor, Charles Berry with State Probation. I spoke with her probation officer, and she has complied with the terms and conditions of supervision as she did when she was originally sentenced. She can't do the interlock because she doesn't have a vehicle, so that's kind of moot. The money was a hardship. Been doing everything else. Her officer recommended just putting it to a judgment and let her terminate.
Well, I thought they said the recommendations was to extend her. I mean, that's what I'm inclined to do, quite
Sir,
frankly.
he actually informed me that possibly the money could be sent to collections, being out of his words was 9 times out of 10 they will do that, being everything else is completed, and I'm not technically in violation because my probation doesn't end until March 9th. And that's what he had told me.
Quite frankly, that's what I'm inclined to do, is reduce it to a lien if she admits the violation.
From my understanding, I have to pay that
If we admit
anyways.
the violation, you just put in a lien situation? Your Honor, you want to put her under oath?
Do what?
You want to put her under oath?
I'm fine with that resolution, Your Honor. The recommendation from probation was made to extend by a year, but that was made prior to her completion of the community service. I think now that we're dealing with the fines only, I think that's an appropriate resolution.
Thank you.
That's how I understand it.
I concur with that, especially based upon what she's telling me her income is. Ma'am, would you raise your right hand to be sworn? Do you swear or affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth?
I do.
What's your name?
Anya Whitfield.
What's she going to do on the violation of probation?
Your Honor, we'll admit to the violation as relates purely to the economic portion.
Right. It's my understanding she's completed the community service.
Your Honor, nobody informed me that, being it was felony, I had to have all my stuff done within the 90 days of my termination of probation. So when I got hit with the violation, I was totally scared to death. Like, just be honest. I think they should tell people that because I was so upset. I really was.
But she's going to admit the violation. All right, the court's going to find that defendant has in fact violated her probation for non-payment. She'll be adjudicated on the VOP for non-payment, and I'm going to revoke her and terminate her probation. Any outstanding fines and costs will be reduced to a judgment lien that will accrue interest at the legal rate. You can also enter a payment program with the clerk's office, ma'am, if you want to do that. You have a right to appeal, 30 days to appeal. If you can't afford an attorney, one will be appointed for you.
Thank
Good
you.
luck to you.
Your Honor, may I approach with the state?
Sure. All right, what about Diara Lewis? She's an...
Morning, Judge. Judge, we have a negotiated plea in this case.
You've got 3 cases, is that right?
That's correct, Judge.
Are you Diara Lewis?
Yes, sir.
Ma'am, would you raise your right hand to be sworn then? Do you swear or affirm the evidence you're about to give will be the truth, the whole truth, and nothing but the truth? Okay, thank you.
Judge, the only thing about this that's unusual is we're trying to get her in a more, and when I say we, I mean both the state and myself, we're trying to get her in a more stable environment. And what we came up with was her father's place in Memphis. He's willing to take her, but we don't know if Tennessee will allow the transfer. So there's a provision in the agreement that if Tennessee won't take her, we'll bring her back into court to either modify it or withdraw her plea, depending on whether or not we can come up with another location.
You know, that's almost a catch-22. The reason I say that is she can't go up there until Tennessee agrees to take her, if they agree to take her. And a lot of times the foreign state, Tennessee, won't agree to take her until she's up there. It's complicated under the interstate compact.
I understand if that's what happens, we'll come up with another, bring her back into court and come up with another alternative. That's why we've got it worded that it would present a modification. I mean, at that point, frankly, her failure to move up there would not be her fault, so she'd have a defense on the any violation anyway. Any violation relating to that. I mean, obviously, if she committed a new law offense or something like that, that wouldn't provide a defense.
Let me see what the attempt is here. She understands she'll have to remain in the county jail until this has been resolved.
Judge, actually, that's not the understanding. She's, if we need to set her off for the 9th to have the assigned assistant here and us straighten that out, we can do that. But she's asked me several times if she would have to wait in jail, and at this point, because I've also been told it may take 2 or 3 months for the approval to take place. She's already been in jail since, gosh, I want to say, write down.
It was opened in August.
August. So her attention has been gotten. Right now, where she has been staying prior to incarceration, she wound up with her boyfriend's parents. That's a pastor and a pastor's wife. Unfortunately, Ms. Bosile and I know that romantic relationships come and go, and so we're trying to get her with, a more permanent family member.
That's correct, Judge. I'm covering for Ms. Bossa this morning, but she has CC'd me to the email thread with Mr. Williams. And essentially what we're trying to do is get her into a stable environment, and so that's why we have the condition of Tennessee with her father in there. I know it's a little confusing. unorthodox, but that was our intention.
Well, I understand the intention of getting her in a stable environment, but it's the interim period of time when she's down here, where she, does she have, what's the situation down here? I mean, the nature of the violation was failure to register. No, that was the underlying obligation. What was the nature of the violation? I don't have that in front of me.
Judge, she was ordered into the REAP program. She was at the REAP program and got kicked out.
Oh, I remember that. I remember reading it now. That was because they said she missed.
She missed a curfew date.
Yeah, she missed curfew.
Or curfew time. There's not been a new law violation. She continued to meet her registration requirements while she was on supervision, and she understands she's got to meet those registration requirements for the rest of her life, that ending probation's not going to affect that.
Well, if she was released today, where would she be going?
Ma'am, where would you go if you were released today?
I have somewhere to stay.
Where
With
is that?
family.
Where?
Here.
Who?
My cousin.
Your cousin lives here in Okaloosa County?
Yes, sir.
In where? Crestview? Shalimar?
Crestview.
Where? Crestview?
Crestview.
The only way I would approve this under these circumstances, if she's released today with a GPS monitor.
Ma'am, do you have an objection to having a GPS monitor put on you prior to your release? I would ask that the court make that $1 a day. That's something we do in this county, and keep the cost down for her.
Is she willing to do that?
Yes, sir. She's indicated
sir.
to me that she's willing.
Ma'am, have you worked this out with your cousin? Your cousin's, or are you just telling me that's where you think you can go?
I called her. She said she'll let me know once I get back to the jail to call her back. So,
She'll let you know.
yes, sir.
No, I'm not going to do that. I need her to have a permanent place where we know she's going to go.
All right, Judge, if we can just set her to come back, I'm going to have to come back on the 9th anyway. We just set her to come back on the 9th.
All right, let's pass it to the 9th at 9 a.m.
All right, we're going to bring you back in on 2/9. In the meantime,
Mr. Williams, let me return the plea agreement and the guide sheet to you. Zachary McKinney.
Judge, this is Zachary McKinney. Judge, we do not have a agreement in this case. I've spoken with Ms. Bosow. I'm going to need to spend more time with Mr. McKinney, so I'd ask that we pass him to February 9th.
Do you have your witnesses? Does the state have its witnesses here today?
No, Your Honor, I saw the email thread. We almost had a tentative agreement this morning, but we need until the 9th to work it out, is my understanding.
February 9th is only about a week away. You're going to be able to get, it's going to be contested, is what you tell me?
Judge, I don't know that it is. He's asking me some questions here at the mic, but I need to have a more substantive conversation with him. I don't mind if we pass it without subpoenas and give us one more chance to try to get it worked out.
All right.
I just need a more substantive conversation that I can have with him either in the back or at the podium.
I understand that. February 9th, agreeable? All right, let's pass to February 9th at 9 a.m.
Okay.
I believe that takes care of all the inmates, is that right? Which one is that?
Briefly, Your Honor, this is Ms. Griffin. I think the state, we spoke outside of our bond hearing, and I believe that the state is willing to stipulate to a $10,000 signature bond with a GPS monitor and intensive mental health reporting for pretrial services. So we want to just, I don't have an order with me. I'll prepare one and submit it to you, to Your Honor. But we just wanted to make you aware that that order would be coming.
All right, send it to Ms. Hoke.
Okay.
And then she can put it in my folder. Now, before you wanted to continue this to have the victim present.
That is correct, Your Honor. In the meantime, I was able to communicate with my office and find out if we were able to get in contact with the victim. And I received information from my victim advocate that the victim would be fine with those conditions.
All right, under that circumstance, I'll go ahead and approve it. Just prepare the order and send it, and I'll sign it when it's entered.
Yes,
Thank
Your Honor.
you.
Thank you. Docket, just to keep track of it? Or is it already set on the 27th?
It should be, but could we verify, please, Your Honor? It should be set for pre-trial on February 27th? Yes, that's fine, so we don't need to address it. Thank you.
February
That's fine.
27th is your next court
Ma'am,
date.
we just wanted to affirm or confirm that you're also scheduled for February 27th, pre-trial conference at 9 o'clock. Your docket day is March 6th at 9 o'clock, and jury selection is March 13th. So you need to be back in court all those dates and times, and that's a condition of your bond as well. No, 227. As soon as I get the order from
I'll submit the order
your
when I get back to the
attorney.
office. Thank you.
I check my file several times a day, so as soon as I get it, I'll enter it.
Your Honor, if I may, I have a plea for an out-of-custody defendant, Mr. Kenneth Garcia. Your Honor, Mr. Garcia is present and approaching. We have reached an agreement with the state. If I may approach with a written plea.
Thank you.
Your Honor, you'll note in this agreement, Judge, that it's going to be reduced to a misdemeanor. He'll be put on 11 months, 29 days of probation at an administrative reporting or an online reporting level. But that's going to be with JCS, Judicial Correction Services. That's the company, the private company in this county that handles misdemeanor probation, Judge. That brings a $50 administrative probation fee one time at the beginning of it. He'll have $270 in court costs, $100 cost of prosecution, $150 public defender fee, or the amounts otherwise reflected on that, Judge. He'll need to take a substance abuse course, which can be done online. He can perform 24 hours of community service or buy that out. That can terminate early at 6 months if he's completed everything. How we want to basically structure that, Judge, is he's going to have until 30 days before the end of his probation. So if he's put on probation today, that would essentially be December 31st would be the day that he needs to provide proof of completion of all of these requirements. However, of course, if he provides them at the 6-month mark or thereafter, he can terminate early.
All right, sir, would you raise your right hand to be sworn? Do you swear affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth? And what is your name, sir?
Kenneth Garcia.
Ms. Garcia, your attorney's handed me a written plea agreement. It's dated December the 12th.
He was originally in this, I'm sorry, Judge.
And it purports to have your signature. Is that your signature, sir?
Yes, sir.
And prior to signing this, did you read it?
Yes, sir.
Did you understand it?
Yes, sir.
Did you go over it with your attorney?
Yes, sir.
Did he satisfactorily explain the terms and conditions of the written plea to you?
Yes, sir, he did.
Do you have any questions concerning it this morning?
No, sir.
Are you satisfied you've had sufficient time to discuss the case and any theories of defense to the charges with your attorney?
Yes, sir.
And are you satisfied Ms. Gibbs, your attorney?
Yes, sir.
Has
Very
anybody
satisfied.
forced, coerced, or threatened you to sign
No,
this
sir.
written plea? Have you had any drugs or alcohol within the last 24 hours?
No, sir.
So what you tell me is you're entering this plea freely and voluntarily of your own will?
Yes, sir.
And you understand, sir, that the felony charge of possession of a controlled substance is being reduced to a misdemeanor possession of paraphernalia, and that's what you'd be entering your plea to. Do you
Yes, sir.
understand that? Maximum penalty on that is a year in the county jail, $1,000 fine, or both.
Yes, sir.
You understand that? And you also understand by entering a plea today, you're waiving your right to trial.
Yes, sir.
All right, the court's going to find that the written plea of Noah Contendere, case number 22-2384, to the, I'm not sure that's a lesser included offense, or is it you just amending the,
Your Honor, you are correct, but we've been doing it without the necessity to amend the information. Like, the court has been accepting it like that.
well, you could orally amend it to paraphernalia.
Then I would, Your Honor, if the court
No
prefers, the state amends to possession of paraphernalia, 893.147.
All right. The court then will accept the plea, finding it to be freely, voluntarily, intelligibly entered. After defendants had the benefit of advice of counsel, the court will accept the plea. He'll be adjudicated guilty of the misdemeanor offense, and it's going to be the sentence of the court, judgment sentence of the court. He'll be placed on probation for a period of 11 months, 29 days, with the JCS, joint, or the online reporting system. He'll pay a one-time fee of $50 for the administrative fee, $270 court cost, $150 public defender fee. He'll be subject to random urinalysis and a substance abuse course online to be completed within 30 days. He'll be required to perform 24 hours community service work, and he'll have the option of buying that out at the rate of $10 per hour. Upon the successful completion of all the terms and conditions of the probation, his probation can automatically terminate without further hearing upon 6 months. Sir, you have a right, and assuming there's been no violations. Sir, you have the right to appeal the legality sentence of the court. If you can't afford an attorney, one will be appointed for you. You have 30 days from today to file your notice of appeal.
Thank you,
Good luck to you, sir.
Thank you.
Thank you.
Did you have any questions?
Oh, I'm sorry. Usually it stops right at the end.
I believe that concludes my business, Your Honor.
Okay. Let's see, did we do Alvarado?
Not yet, Your Honor.
Okay.
Do you have anybody else, Chair?
Maximiliano Alvarado.
No, I'll do it from up here.
This is a motion to compel discovery, is that right?
It is. Justina Turner for the defense and for Mr. Alvarado. He is not present. There is a waiver in the file for his appearance. Your Honor, this is 19 CF 2316. Now, at the time that I wrote this motion to compel, we were under the belief, based on discovery from the state, that there was what I would call a missing 911 call made that had not been provided to us, to the defense. But I have spoken with the state attorney at length about this issue since the time I wrote this motion, about whether or not there ever existed an additional call between the alleged victim in the case and the 911 operator. Because in one of the calls that we have, the 911 operator instructs the alleged victim to call back on a specific line. She gives the phone number. And it is through my speaking with the state attorney recently that I've learned that that number is, in fact, the non-emergency recorded line for Cretview Police. So really, I would sort of do an ore tenuis modification of my motion for any sort of conversations or communications that were conducted back in October of 2018 between the victim and law enforcement on that specific recorded non-emergency line.
Do you know that non-emergency line was recorded?
Well, Mr. Rogers here for the state has told me that it would have been.
And Judge, yes, it is correct, Your Honor. Zach Rogers for the state. So, Your Honor, what we're dealing with are 3 different 911 calls that have been provided to defense. We've got a call A, in which the victim in this case had called Okaloosa County Dispatch. She was transferred to Cretview Dispatch. The Cretview dispatcher collects her phone number. Gives her the non-emergency Cretview dispatch line, instructs her to call back. We have a call B, in which the Cretview dispatcher contacts an Okaloosa County Sheriff's Office deputy who is at the Okaloosa County Airport where the victim was located and instructs him that the victim will be finding the deputy and make contact with him. We then have a call C, in which the Cretview dispatcher actually called the victim back. And they have a substantive interaction where the dispatcher has collected information from the victim about what occurred that evening. Ms. Turner's motion, and please correct me if I'm speaking out of turn, relates to the fact that the information which is written in the CAD report, the summary of the interaction between the dispatcher and the victim, is incongruous with what is heard in that last 911 call. And so, based upon that, Ms. Turner believes or suspects that there may be an additional call. What I can represent to the court is that my office collected the relevant calls on 2 different occasions from the Cretview Police Department. The first time was in 2019 at the inception of this case, at which point the 3 calls were provided to defense. After Ms. Turner filed the motion to compel in this case in early 2022, my office again went back to Cretview Dispatch and followed up, said, please make sure that you've acquired all of the relevant calls. Again, they came back and provided those same 3 911 calls, which were originally provided to defense. Once again, this morning, I confirmed with Cretview that that 3rd 911 call, the substantive one between the Cretview dispatcher and the victim, was on their non-emergency dispatch line. That is a lot of information for me to essentially say to the court that we have provided all of the existing recordings related to this case to Ms. Turner. Now, I have told Ms. Turner that I'm going to follow up with them one more time and ensure that they have in fact provided us all of their information, just to ensure that all of the relevant discovery has been provided to defense. I've also told Ms. Turner that I'm going to follow up with Okaloosa County Dispatch to ensure that we've received any CAD notes or recordings from them, just to lock this issue down and ensure that Ms. Turner has been provided with all relevant recordings.
What about the call that was inconsistent with the CAD report?
So, Your Honor, here's what occurred based upon what we can hear in the 911 call. So there's a couple relevant points. The first is that in that 911 call, the dispatcher asks the victim what her name is, indicating, of course, that that exchange had not occurred previously. She then asks, you haven't changed clothes or showered, right? She's asking the victim that. The victim says, I did, but I have the clothes in my bag. Now, at the very end of that call, the phone is passed by the victim to Deputy Sheriff Peters, who is present at the Okaloosa County Sheriff's Office, essentially to confirm for the dispatcher that the victim is in the right place, that she's encountered the Okaloosa County Sheriff's Office deputy. And in the context of that exchange, the dispatcher says to Deputy Peters, she says he's already made her change clothes. I don't know if she's already showered. Now, the reason that that is notable is that that information is inconsistent with what the victim had just reported to the dispatcher. And of course, my general concern for this motion and the circumstances generally is that this dispatcher entered erroneous information on the CAD report based upon that specific call, that there is no other 911 call at issue in this case. Now, despite that fact, I have told Ms. Turner that I'm going to do the due diligence in this case to ensure that that is, in fact, what's going on.
All right, what I'm going to require then is, you said you're also going to verify that there's no further calls with the, down at the south end?
Yes, Your Honor.
All right. Once you do that, Mr. Rogers, and you're satisfied you've furnished everything that there is to the defense attorney, just file a notice with the court file that every tape that is in the possession of the state or the sheriff's department has been furnished to the defense.
I will do so, Your Honor.
Just to repeat that, that's a court filing that Mr. Rogers files
Once
from
he
IT personnel.
Go ahead.
I'm sorry. It would be from somebody with knowledge at the law enforcement level to certify that all calls have been provided to the state,
That exist.
that they
That
have.
exist. In other words, I want something in the record that the state has made a good faith effort, done their due diligence, and they're satisfied that all the tapes or the conversations that exist have been provided to the defense. I mean, I'm going under the assumption that if they have them in their possession, they're going to provide them to you.
Yes, of course.
I want to make sure that the sheriff doesn't have anything that they haven't provided to the state. And once the state's satisfied that's the case, just certify that everything that they're aware of has been provided to you.
Yes, sir. And Mr. Rogers was good enough to give me the names of some of the, I think, maybe IT personnel at the law enforcement level who could also answer some further questions for me about that line.
In control of their records.
Yes. So I think that addresses the motion to compel, which is what we had noticed for today, Your Honor.
I was going to say, that was the only thing I saw noticed for today. Is there another issue?
No, no, sir. We talked about the sheriff's, going to the sheriff's office and then doubling down with the Cretview Police, so that's all. And I would just amend my motion to ask for that relief.
Relief of what? You want what?
Well, in my motion, Your Honor, I noticed that at that time, I had asked for the information for the 911 operator, but I've gotten that since then, so I just wanted to make sure, to make the record clear that my motion was drafted. I've received everything at the time that I drafted the motion, plus the additional things that I asked for today.
Any problem with providing what she's asked for?
Your Honor, I intend to follow up with the notice that you have ordered.
Yes, sir.
All right, that should take care of it. Thank you.
Thank you, Your Honor.
Thank you. May I be excused, Judge?
Yes, ma'am.
Thank you.
Judge, we have
What about-
Connect on the,
Who?
Connect.
Yeah, that's the one I was going to ask about. What about Ethan Connect?
All right, Judge, we ordered the Court Smart. It should arrive today. So I'm simply going to ask to pass it until the 9th. This is the one where I'm saying that we actually entered pleas to everything, and the clerk was saying that we
Oh, I
didn't
remember that from the other day.
enter a plea. I did pull the plea and sentencing agreement from the clerk, as well as print out the clerk's docket. This case, 22 CF 3113, is on the plea and sentence agreement. So just so the court's alleviated, we're not just trying to delay things or screwing around here or something like that.
All right, you think you'll have that by the 9th?
We have been told we will have that disc today.
Oh, today? Okay.
Yes, sir.
All right, well, the next court date is the 9th, so let's set it the 9th for 9 a.m.
Thank you, Judge.
I think that's, I see a couple people sitting out here, but, oh, okay. That's all I had on my docket. Is there anything else?
No, Your Honor.
I don't have anything else, Judge.
All right, what about the clerk? You have anything that I missed? All right, we're adjourned then. Thank you, folks.
Thank you, Judge.
As always, appreciate your help.
Yes, sir. Thank you.